Hi, and thanks for joining us in a presentation about renters' rights in Texas. We're going to cover a bunch of topics today. Before we get started, it's not a good legal presentation unless we have a disclaimer. So we'll start with that. Update all materials to account for changes in applicable laws. This presentation is based upon the law at the time it was created. The law changes frequently and is subject to various interpretations by different courts. Future changes in the law may make some of the information of this presentation inaccurate. The presentation is not intended to and does not replace an attorney's advice or assistance based on your particular situation. This presentation does not constitute legal advice nor form an attorney-client relationship between you and Lone Star Legal Aid or any of its attorneys. So who are we that are going to be talking about these issues today? Amanda, if you want to introduce yourself.
Sure. My name is Amanda Powell. I've been with Lone Star Legal Aid for 4.5 years. And before I transferred to MLP, which is our medical legal partnership unit, I was in our fair housing unit, in our equitable development initiative unit, where I handled fair housing discrimination, eviction defense, reasonable accommodation, subsidized housing terminations, and those sorts of things. So thank you and welcome.
And my name is Pete Makapoulos-Senftlebar. I'm also a staff attorney with our medical legal partnership unit, where I'll talk about a little bit more in a second. We help with an array of civil legal issues, but before coming to Lone Star Legal Aid, I practiced mostly employment law and commercial litigation. And after realizing that there's a lot more issues and people out there that need my help that I was more passionate about, I decided to go to Lone Star about 3 years ago to help with that. So what we do, Lone Star Legal Aid's medical legal partnership, or you'll hear it's abbreviated as MLP, connects patients of participating healthcare clinics with free legal services. LSLAs, another acronym we'll throw around, Lone Star Legal Aid's MLP can assist with issues like evictions, child custody, Social Security benefits, divorces, guardianships, and many more issues. Lone Star services are free. Our participating legal clinics, our MLP clinics are listed on our webpage at that link right there, lonestarlegal.org/services/medical-legal-partnership. At the time of this presentation, which is August 2024, our MLP clinics are with UT physicians, and they're located throughout the Houston area. You can see the various locations at that link. So topics for discussion today, we have eviction, repair requests, repair remedies, accommodations, and discrimination protections. So we'll start with the least fun of the batch, in my opinion, evictions. Evictions, if possible, should be avoided, but like most things that happen that are unfortunate, that can't always be the case. You should avoid an eviction because it can negatively impact your credit or your ability to rent, and it can jeopardize your future housing. Even if somebody may be willing to rent to you in the future, which a lot of landlords and property management companies are not willing to do if you have a recent prior eviction or a prior eviction in general, they may have other terms for you, like an increased security deposit or something like that, that can make the terms of that housing less favorable to you. So again, you should avoid the eviction process if at all possible, but like many other bad things, sometimes it is inevitable. So what do you do if you are being subject to an eviction? What are your rights and what is this process going to look like? Well, the good thing to know first is that Texas law does not allow for what are called self-help evictions. Basically, your landlord can't come to your door, change the locks, and lock you out or throw your property on the curb. They have to follow legal processes and procedures. Unless you abandon the property, the landlord cannot remove you or your personal belongings from the premises until the eviction process is completed and that action is ordered by a court. A lot of times people don't know the reasons a landlord can or cannot evict you. There are certain specific reasons that they can evict you and certain specific reasons that they cannot evict you. A reason a landlord can evict you is because you did not pay rent on time. This is the most common issue that people are evicted for. But landlords can also evict you for other lease violations. So anything that it says you're not supposed to do in your lease, if you're doing that, you can probably be evicted for it. Some other common examples are having an unauthorized pet or someone live with you who's not an authorized tenant, because you cause property damage to the property, or because you're conducting an illegal activity on the premises. And again, you can also be evicted for other issues that are lease violations. As you probably know, your lease is many pages long and has other things that you can and cannot do. If you're doing one of those things you cannot do, it's likely that your landlord could evict you for it. So make sure you read the terms of your lease, know what you're not supposed to be doing, and don't do those things. Because if you do, you can find yourself subject to an eviction. A landlord cannot evict you because you requested legitimate repairs, because you filed a complaint or exercised a legal right, or because of your race, color, religion, national origin, sex, disability, or familial status, or because you're a military service member impacted by military service. And what you want to think about here is those things on the right side of this, the reasons the landlord cannot evict you. They can't evict you based on those particular reasons, but if you're doing something in the left column, like not paying your rent on time and they proceed with an eviction, they're not necessarily evicting you for one of the reasons on the right column. So what you want to be sure is that your protection from, or what you want to know is that your protection from eviction on the right-hand column is only because the landlord's evicting you for one of those reasons, not for the other legitimate reasons on the other side of the column. What does the eviction process look like in Texas? I know I just told you they can't just lock you out, throw your things on the curb. They have to go through a legal process, but what does that legal process look like? Well, the first step in the process is something called a notice to vacate. The notice to vacate is a very specific piece of information that has to be delivered in a particular way. A notice to vacate in Texas has to give you 3 days notice to vacate the premises, or you're going to be subject to the eviction. This time can be shorter if it says so in the lease. So if your lease says you agree that we can give you a 1 day notice to vacate, a 2 day notice to vacate, then that is legitimate and you can get a 24-hour notice to vacate. So again, go back to your lease and look at there and see those terms. It might specify that you can get less notice than 3 days. But if your lease doesn't say anything about how long you should get for a notice to vacate, it's by default 3 days at least before you could be asked to move out or have an eviction filed against you. The notice can be delivered in person, by mail, or by posting it to the inside of your front door. This is the most critical part of the notice to vacate information because this is the part where landlords mess up the most. And it is the part where most people can have a defense to an eviction. If you do have one, this is probably going to be it. A landlord can't post the notice to vacate on the outside of your front door unless there are specific requirements followed. So if there's no mailbox and they can't send it to you by mail, or they can't enter for some reason, like you have a rabid dog barking at the door, or they think they're going to be injured because you've threatened them before, something like that, they can post the notice to vacate on the outside of the door, but they still have to follow additional requirements. For example, they can't just tape the notice to vacate just without an envelope or anything in it. It needs to be in an envelope that's marked in big inconspicuous letters, important documents, or something similar to that. So a blank envelope, that doesn't get them there. An envelope that says number 24B doesn't get them there. It needs to say important documents or something similar to that. We'll talk a little bit about what you can do to preserve this defense or make the best case of it in a few slides when we talk about defenses to eviction. So just kind of bookmark this in your brain about the notice to vacate. Once you get a notice to vacate, if you don't move out by the date on that notice, the landlord can then file the eviction lawsuit in Justice of the Peace Court, which is sometimes called JP Court. A petition for eviction will be filed in JP Court, and then it will be served on you. Chances are it's not going to be dramatic like the movies, where you get thrown the papers while you're getting your morning coffee, but you will be served likely by a constable or a private process server, and they will hand you those documents. Trial will be set in JP Court within 10 to 21 days from the date the landlord files the lawsuit. So you might have heard or personally experienced the wheels of justice turning slowly for most types of cases, and that is true. There's often a lot of delays and time taken in courts, not for evictions. Evictions are intended to be speedy remedies, so things happen quick with evictions. So you need to be sure that If you're watching this, you're already a step ahead. You're knowing your rights before you hopefully need to exercise them. But you need to be sure that you're paying attention to the documents that you're getting, because 10 to 21 days, just a little over 1 week to 3 weeks from the date that they file the lawsuit is not a lot of time. Following the filing of the lawsuit and the setting of that lawsuit for trial, either party, so once you have your trial, either the landlord or the tenant can appeal the JP court's judgment to the county court, which is the next level in the appeals. But to do so, you have to file that appeal within 5 days from the date of the judgment. Another quick turnaround. For most other civil appeals, you have 30 days or sometimes even longer. But for an eviction appeal, you're only going to get 5. If a judgment against you is not appealed within 5 days, the court can issue what's called a writ of possession. This writ of possession is the document that allows them to do those things that we said they couldn't do without following this process. It allows them to remove you from the premises and to remove your property from the premises. Once they get that writ of possession, a constable can or has to give you 24 hours notice at least before they actually do that removal. So you're going to get another 24 hours or maybe a little bit longer, depending on how long the constable takes to actually execute this writ or go through with getting you and your property off. You'll get like one last warning that's going to give you at least 24 hours notice before you have to do that. But at this point, you need to be ready to have all of your possessions out or be out if you're not out already. So the timeline, what does this look like that we've kind of walked through in a visual format? As you can see, if you get a notice to vacate and you move out, an eviction should or won't be filed against you. If you get a notice to vacate and you don't move out, then an eviction lawsuit gets filed. And 10 to 21 days from that date, there's the trial in JP court. And then in 5 days, if you don't file for an appeal, the constable can issue a writ of possession. And then 24 hours from that writ of possession, they can remove you and your property from the premises. Or if you do file an appeal within 5 days of the JP court judgment, you have at least 8 days before there's an appeal trial in county court. And then if you lose there, you're going to have that writ of possession executed again, which is that kind of last shot warning where you get 24 hours before the constable removes you and your property from the premises. So defenses to eviction, what can you do if you're subject to one? If the eviction is retaliatory, so like we were talking about earlier, if you give your landlord notice of legitimate repairs that you would like made that impact your health and safety, which we'll get into those in just a bit, and they say, well, I'm not going to make these repairs, and on top of that, you're evicted. I don't even want you here. I'm filing a lawsuit to evict you. That's prohibited. That's a defense to eviction, that they're evicting you just because you want them to make your living conditions habitable. That the eviction is discriminatory. They're evicting you on the basis of your race, your gender, your national origin, some sort of protected characteristic. You are not given any notice to vacate. That's a great defense to an eviction because you have to be given a notice to vacate. But the most common defenses to eviction are these last 2 points. That you were given a notice to vacate, but it was defective, or that you were given a notice to vacate and it wasn't properly delivered. So they sat it outside of your door. It didn't have an envelope. It didn't say important documents. It was wedged between your door frame and it didn't have an envelope. It was slid under a doormat. All of those things are improper deliveries of that notice to vacate and can be a defense to your eviction. So what should you do if you're maybe subject to an eviction? Well, first, and this is the most important point, I think, take and save photos of any legal documents delivered to you, especially any notice to vacate, before you touch it. Why is that important? Well, if your defense to your eviction is that the notice to vacate was sat outside your door with no envelope, nothing that said important documents, it's really compelling if you can show a time-stamped photo of exactly that, a taped piece of paper on your door with no envelope and no writing that says important documents. Otherwise, the court's evidence before it is going to be your testimony, which they may not be inclined to believe, or the other side, the landlord's testimony, which they may be inclined to believe more than yours. And so to give yourself the best chance, if you have that nice timestamp photo of exactly what you're describing, that helps show that what you're saying is true and provides some of that proof in a tangible way. It's also really important because you can show any potential attorney that you reach out to, here's how it was delivered, and they can look at it and tell you if it was valid or not. So before you touch the document, pick it up and move it. I know it seems strange. Take a picture if you see something taped to your door, wedged in your door, you think you might be getting a notice to vacate. The second point, talk to your landlord to see if you can avoid them filing the eviction. That's critical because, again, once the eviction is filed, it may not impact your credit, but it could impact your ability to rent in the future because it's showing up on your rental record. And so you don't want that to happen. You want to avoid it being filed if you can at all. So talking to the landlord before that eviction is filed is generally a good idea. If you do come up to an agreement with them, make sure to get that agreement in writing, a signed writing with them that's dated. This way that you have proof and something that you can hold them to, that you have this agreement in writing. And because most leases will not allow any agreements to be made outside of the lease unless they are in writing, that is particularly important. Third, gather and save any evidence of past rent payments. If the apartment is alleging or the house is alleging that you did not pay past rent and you have proof that you did, well, gathering those bank statements, those checks, money orders, things that you provided will show that you did make those payments, and you may be able to use those as evidence. Find and review your lease. I think I've said the word lease about 10 times so far, maybe more. That's because that's always the controlling document in a case where you're fighting your landlord. That's the agreement between you that's going to show who is supposed to do what and when. And so all of those terms and those specific agreements between you two are going to be in the lease. It's going to be really important because it may give you insight about rights that you have that you didn't know you had, or it may tell you things like how long you have to get a notice to vacate that your landlord may not have complied with, and you may have this as a defense to your eviction. 5, try and obtain legal counsel if you can. If you're in an eviction for non-payment of rent, you probably can't afford to pay a private attorney, but there's lots of legal aid providers out there like Lone Star Legal Aid. Give them a call and try to see if somebody can help you free of charge. And then finally, this is probably second most important to the first point, comply with all court notices and deadlines. Sometimes simply just showing up for an eviction hearing can preserve your rights. Even if you're not a lawyer, even if you don't have a lawyer with you, even if you don't think you know what you're doing, just being there can change how an eviction process goes. All right, so repair requests. I mentioned earlier that if you have something going on in your home, you give your landlord notice, ask them to make the repair. Most people, I think, know that renters should have a healthy, clean place to live. That's what they're paying for, and their landlord is responsible for making sure that that's the case. The law that sets this out is Texas Property Code Section 92. This says that Texas renters have the right to have any condition that materially impacts their health and or safety, and it's not caused by the tenant. So if you go and put a dangerous chemical in the middle of your living room, they don't have a duty to repair that. You did that yourself. It's not caused by the tenant, your household members, or your guests, unless it was caused by normal wear and tear, repaired by their landlord. So any kind of outside occurring conditions or normally occurring conditions. You're entitled as a Texas renter to decent, safe, and sanitary housing with secure locks on your doors and windows, hot water, and smoke detectors. So how do you go about getting these repairs made? You have to you have to follow certain specific steps before you can exercise any rights that you have, including requesting the repairs, which is the first step. So if the landlord doesn't know about an issue, that's not going to trigger any legal obligation on their part because, well, they don't know about it. How are they going to fix it? You have to tell them what needs to be fixed and do so in a particular way. So before you request repairs, there's a few things you need to think about. The first is, are you current on your rent? You can't refuse to pay your rent because the repairs aren't made. I know it might seem like that's a good and equitable remedy, and I might agree with you on that, but the legislature in Texas doesn't, the law doesn't say that. So if you're not current on your rent, your landlord doesn't have to make repairs. So it's a catch-22. You say, I'm not paying my rent because you didn't make the repairs. Then the landlord says, well, I'm not making the repairs because you didn't pay your rent. Don't get stuck in that situation. Pay your rent and then hold the landlord's feet to the fire and make them do what they're supposed to do. The repair request has to be for something that materially impacts your health and or safety. I know sometimes paint colors are ugly. I know sometimes carpet doesn't look that pretty to you anymore, but those generally aren't things that materially impact your health and or safety. Maybe your aesthetic and your sanity, but not your health or safety. So common examples of things that impact your health and safety are things like electrical problems, plumbing problems, mold, bugs, rodents, lack of hot water, and broken windows. Things that, if you just simply put, make you feel unsafe or cause harm to your health. Once you've made sure that your rent is paid up to date and that the repair that you're asking for is something that should be repaired to the landlord, now it's time to actually request those repairs. How do you do that? Well, like you might expect a lawyer to tell you, get it in writing, make your repair request in writing. Include the date that the writing was sent, whether it's a letter or an email, make sure that's noted. Include your name and address. Identify the issues to be repaired, not just, this is Sam from Unit 3B, everything's horrible in here. You need to say, my plumbing's not working, my stove, I think, has a gas leak. Whatever is the issue, you need to tell them that. You don't need to be a mechanic and diagnose it yourself. You don't need to be a repair person. You just need to specify what the issue is. State that the issue is a threat to your health and or safety. That always is a good way to trigger people to get in there and start making the repair with some haste in a short amount of time. Ask for the repairs to be made in a reasonable amount of time. Request a written response if the repairs cannot be completed within 7 days from the date of the letter that you're sending them requesting the repairs. Why 7 days? Well, when I said reasonable amount of time in the earlier point, the law in Texas presumes that 7 days is a reasonable amount of time. Obviously, that can vary. If your complaint is that raw sewage is coming out from in your bathroom and just will not stop, 7 days isn't reasonable for an active raw sewage leak in your home. However, so that might be shorter for that. However, if you say, I have bugs, 7 days probably is reasonable for bugs. So it can be a little bit shorter than 7 days if the circumstances warrant, but normally 7 days is reasonable. So tell your landlord, if you can't come within 7 days to make these repairs, tell me why in a written response. Make sure you sign the letter, you put your name on it so that they know who it's from, and deliver the letter to the right person or place. And then send it by regular mail and then some other form of trackable mail. So it can be certified mail, or you can send it UPS with tracking or FedEx with tracking or something like that. Or if you're going to hand deliver it, bring a little receipt with you. It doesn't have to be fancy. I blank got this notice on blank day from tenant's name. What should it look like? Like I said, it doesn't have to be fancy. It can be simple. Here's an example of it. We have a self-help repair packet that we'll distribute with the files for this, and it will have this document in it where you can just fill in the blanks. Again, nothing super fancy. Date, who it's to, what the address is for repairs, dear landlord's name, I'm you, living at, address, and then asking you to repair those conditions. And then that magic language at the end. It continues to threaten my health and or safety. I need it repaired in a reasonable amount of time. It needs to be 7 days. If you can't repair it within 7 days, tell me why within 5 days after the date that you get this letter. And then sign it and write down how you sent it. So here's another example of that. What happens if they don't do it? What happens next after 7 days? My landlord is still not fixing it. Well, probably not going to like this part, but the next step is send another letter. It's not fun, but it's what the law says we're supposed to do. Send another letter that looks almost the same, but in this one you can say, this is my second request, and then you get to add some more special language to this one. If you don't comply with this request, I might terminate my lease and move out, and I might sue you and try to get other damages here. This is your final notice. Once you send this notice, maybe that prompts them to make the repairs that they should have made 1 week ago. But sometimes they still don't, and we'll get to what happens after that. But in the meantime, save a copy of any written request that you sent to them, as well as any receipts from the post office or whoever you use to send that tracked mail, and send those tracking details so that you can show it's actually delivered. Some leases say that you should email these requests or submit it through a website or resident portal where the notice should go. If this is the case, email or upload it exactly as the lease tells you to, but you should also send mailed copies if you can to the leasing office or wherever you pay rent. If you email or upload the request for repairs, sometimes they'll lock you out of those accounts. They go dark after 30 days. They won't show up anymore, where your email will get wiped or deleted. You don't want that to happen. So be sure to print or save a PDF of whatever you submitted from the resident portal or on your email. So save all of those documents. And again, when you're figuring out where to send this, it should be wherever it tells you to say notices should be sent in your lease. It's usually toward the end of a lease agreement, but it depends on the lease. Or if there's nothing in your lease about where notices should be sent, you should send it to the place where you ordinarily pay rent. So sometimes that's a leasing office, sometimes it's a landlord's mailing address. Just use that address as the one you're going to deliver these notices to. All right, so we're here at the point where we didn't want to be. We requested repairs, they didn't make them. We requested them a second time. We let our 7 days pass again, and here we are in our home with mold on the walls and no repairs made. We've made these requests. What do we do now? Well, I'm going to recommend that you get professional legal advice because there's 3 options and they each have their own little hoops and hurdles and hangups. And it's always a good idea to get legal advice before that's specific to your situation before you do any of these things. But your basic options are move, sue, or repair and deduct, or a combination of these. So option 1, move. You've got to give your landlord that written notice that you're going to be terminating your lease, that the date that you're going to be moving out on, that you're entitled to a refund of your security deposit, and that you're entitled to a refund of your rent for the remainder of the month following your move out date. So remember what we said earlier, you're not holding back the rent payment because they won't make the repairs. So you've already paid for August, but you're moving out today, August 8th, and you need a refund of the rent from August 9th, the end of the month. If you terminate your lease and move out, this is the part some people like, you can still sue your landlord for certain damages. Option 2, sue. So this you can exercise whether you moved out or not. You can sue your landlord and you can ask for an order reducing your rent dating back to the first request for repair. So 3 months ago, I asked you to repair the mold in my apartment that I'm renting for $1,000 a month. And you didn't make those repairs, and I'm still here. I think most people would only pay $200 a month for an apartment with mold in it. So I'm entitled to $800 per month in damages for 3 months. That's kind of how that would look. That's what you can ask for. Whether the court will award it or not is up to their discretion, but it's something you're entitled to seek. You can also ask for an award of 1 month's rent. So my $1,000 month's rent plus $500. So $1,500 in damages in that case where my rent's $1,000 a month. You also can ask for any actual damages you incurred. So you had a broken window and you got cut on some of the glass, you had to go get stitches, and you got a $2,000 medical bill. You can ask for those as part of the damages that you're asking for, or damages to your personal belongings. Somebody jumped through that broken window and they took your TV and all your valuable jewelry and things like that. You can ask for those to be part of your damages that you get in any award from the court. And then finally, you can also get attorney's fees and court costs. So if you do hire a private attorney, they're charging you by the hour. You can ask for those to be paid to you by the landlord, and then the cost of the court for filing a case and doing things like that. If you have not terminated the lease, you're still living in this unit and it's still not repaired, you can also ask that in addition to these monetary damages, the court order that the landlord repair those conditions so that they actually get made while you're continuing to live there. Option 3, repair and deduct. I almost never recommend this one because it's complicated and technical. Generally, you can hire a qualified, uninterested third party, so not your brother that you're going to pay to make the repairs, and not yourself to make these repairs. So you can find someone on wherever you find repair people, and you can hire them, and you can pay them and deduct the cost of those repairs, or up to 1 month's rent or $500, whichever is greater, from your rent payment. This doesn't cover all the details that you have to follow to use this option, and that's part of the reason I don't recommend it, because then you get yourself in a situation where maybe the landlord is seeking damages against you, and I do not recommend this. So again, going back to, if you're in this situation, try to get some specific legal advice before you do any of these, but especially this option. Can you do anything else? Yes. Moving, suing, complicated repair and deduct process is not something that everybody wants to do for a variety of reasons. Moving is expensive. This is time consuming, emotionally draining, all of those things that are not fun to do. So what can you do instead of one of those options? You can try to push for repairs to be made using kind of more creative solutions. You can contact the city of Houston or other cities' inspector's office and request an inspection. For the city of Houston, you can do that online or by phone at that number. You can file a complaint with the Texas Office of the Attorney General. You can do that online or at that phone number. Or you can submit a complaint to or request an inspection from the housing authority that manages your housing voucher or public housing if you are on a housing voucher or in a public housing facility. And with that, I will allow you to stop listening to my droning and pass it over to Amanda, who's going to cover a couple of other really important topics.
Thank you, Pete. Oh, sure. So I'm going to go a little bit deeper and a little bit more technical than Pete, and we're going to talk about reasonable accommodations. And before I get into reasonable accommodations, I want to explain what law provides for reasonable accommodation. So the Fair Housing Act, which is also known as the FHA, prohibits housing providers, from discriminating against you based on your race, color, religion, sex, disability, or family status. And the Fair Housing Act also allows for disabled individuals to request reasonable accommodations. So what is reasonable accommodation? Reasonable accommodation is where a disabled person is asking or requesting of the landlord to make accommodations in their policies, services or practices. And in order to do so, the reasonable accommodation is specific to disabled individuals. And the ADA has defined a disabled person as someone who has a mental or physical condition that substantially limits one or more of your major life activities. So those activities could be breathing, walking, manual tasks, lifting, any of those things that prohibit you or limit you substantially from doing is a qualified disability under the ADA. Specifically, the Fair Housing Act requires landlords to afford people with disabilities an opportunity to use and enjoy their home and common areas. The FHA also makes it illegal to refuse reasonable accommodations to rules, policies, and practices or services for tenants with disability. That is, if there's not some type of undue financial burden and hardship on the housing provider that might enable or might legally allow the housing provider to refuse your reasonable accommodations. So what are some other laws for which a disabled person might pursue a claim against a housing provider who has discriminated against them, specifically a disability discrimination? Well, Section 504 of the Rehabilitation Act gives also the same protections as the Fair Housing Act and prohibits housing advisors from discriminating against people who have disabilities. The Section 504 is specific to housing providers who actually receive federal funding. So tenants who are under subsidized housing programs, whether it be Section 8 or Section 811, vouchers, public housing, those sorts of things, would typically refer to Section 504 of the Rehabilitation Act to enforce their rights to fair housing. Okay, so the actual accommodation requests: who, when, how, and what. So who can make the request? Obviously, the person who has a disability, a minor with a disabled parent, a caregiver for the individual with a disability, or a household member of the person with a disability. You can obviously request it at any time. You can request, even if you are, for instance, applying for an apartment complex and you have a disability, whether it be, you know, site issues or whatever, and for the application process, you might ask them to accommodate you by maybe allowing you to fill out your application in the office, or instead of online, which is where they typically have their applications, and it's also the practice and policy of the apartment. And so that's an example of how you're asking the apartment to make accommodations in their policy. You should also make sure that this request is in writing. And it's strongly recommended that when you make the request, that you give kind of a description of your disability, particularly if it's not obvious. And the next slide, we're actually going to go over those situations in which you might need to be a little bit more detailed in order to make sure that the housing provider understands how your disability relates to the accommodation you're requesting. You don't have to use the words reasonable accommodation, but it's helpful to use it, particularly as more and more landlords are coming to these tenant rights events and understanding more of what they're supposed to be doing. Sometimes the word reasonable accommodation, they, might trigger them to respond faster. So what are some examples of accommodations? Say, for instance, you have mobility issues where you use a wheelchair or a walker, and you might ask the landlord, hey, can you assign me an accessible parking space? That's an example of making a request based on your disability. Another example is where a landlord might prevent you to transfer to a ground floor. A lot of these apartment buildings have multiple levels, and for people who do have mobility issues, it's of great help and a need for them to be on ground level to have better access to their apartment. You might also, which a lot of people don't realize they can do, or a surprising thing that might strike some people, is you might ask the landlord to adjust your rent schedule to allow you to pay, particularly those tenants who receive SSD, where you're receiving a Social Security disability check that comes after the due date of the lease term for which you're supposed to pay. You might ask the landlord to accommodate you by allowing you to pay your rent after the due date, and of course waive late fees. This is actually case law that actually provides that this particular asking the landlord to accommodate you based on rent payment is considered reasonable. So the biggest thing with accommodation is making sure it's reasonable. I mean, obviously you can't ask the landlord to reduce your rent just because you have diabetes, for instance. So it's just understanding what you need and how you need the landlord to accommodate you. Another example is maybe we mentioned this earlier, permitting an applicant to submit their application another way. whether it be in person or online, that sort of thing. And the last example is one of the most common ones, and I've personally had a case, an eviction case, where I had a tenant who had an emotional support animal that resided with him in an apartment that said that didn't authorize pets. And he did submit a reasonable accommodation request for which the landlord did not honor. And then on top of that, the landlord evicted him for breaking the lease, which is a lease violation, as Pete stated, where you have to make sure that you understand the lease. Well, he did ask accommodations for the landlord to change their policy with regard to his disability and allow him to have a pet. We ultimately were able to get the eviction dismissed based on reasonable accommodation. Okay, so the obvious disabilities are going to be a little bit easier for your housing provider to make or grant a reasonable accommodation. And they should grant it without delay. Case law has actually even said that a delay in granting reasonable accommodation can also be considered a denial of or refusing reasonable accommodation, which is a violation of FHA. Your housing provider might ask you, for additional information. The key is here, particularly if your condition is obvious, you're walking around with a walker or some type of dog that helps to guide you because you're blind. The request from the landlord has to be reasonable, and he only needs medical information to the extent that verifies your disability. So you don't need to give or disclose your full medical history to your landlord. Some of the most non-obvious disabilities also, for example, or specific to mainly mental disabilities where it might not always be clear. In those cases, the landlord can ask for what's called a verification. And that's typically something provided from your healthcare provider, your doctor, sharing a little bit about your disability. So your housing provider can have an idea as to how your disability relates to the accommodation you're requesting. So when can accommodations be refused? So a housing provider may refuse your accommodation request if it's an undue administrative or financial burden, or even if it's a fundamental altercation in their program. Some of these examples might be a little bit difficult to give examples of, but the one that comes to mind in terms of a housing provider that may refuse your reasonable accommodation request could be that you might be asking for something that's financially, it's an undue financial burden or a huge fundamental altercation. The example that comes to mind is maybe an individual who's sensitive to smoke and is maybe asking the landlord to make the building that she lives completely vacant, where she's the only one in the building, so that she can be away from whoever might contribute to smoking and her being exposed to it. That is one, not reasonable, and then obviously it'll probably fit within one of the legal reasons as to why a housing provider might refuse your request. Okay, so when can accommodation requests be refused? Okay, we talked a little bit earlier about some of those specific examples. It also might be that what you're requesting, like I said, is unreasonable, or it's just not practical for the housing provider to do. And in this case, you want to engage with the housing provider to have an interactive process to engage with the provider to come up with suggestions on how he might be able to accommodate your disability. This is important because the landlord is always supposed to work with you in terms of honoring, helping to honor your requests, particularly when it is important to provide you equal opportunity and accessibility to your home. Okay, so I did mention already earlier about FHA and what it's about, and these are the particular class protections for which protected individuals or protected by the FHA: race, color, national origin, religion, I'm sorry, sex, familial status, and disability, of course. So some examples of discriminatory acts, and these things aren't as most, I know some people don't realize this, but discrimination is not overt. And you know, thanks to civil rights laws in the 1950s and 60s, unfortunately, there's a lot of things that people can't do or shouldn't do, and other people have found ways to do things subtly to avoid seeming like they're discriminatory against you. One might be refusing to rent or sell to you. That, I mean, it might be an excuse that, hey, you know, and these things are a lot of times gonna come with a lot of other factors included that help you to make those determinations on whether or not he's refusing you, or the landlord is refusing you to sell to you because of your race or color or sex and those sort of things. If they refuse to negotiate for housing, or if they try to make housing unavailable, you know, for instance, whether, I'll just take as an example, if you're a Black person and you're renting, you're interested in a home, you want to buy a home, not just renting. This applies to applicable to people who are buying as well. And it's also the FHA. There's other people subject to the FHA besides just landlords, mortgage lenders, real estate companies, insurance companies. They're all subject to the FHA laws too. But you know, you might inquire about a home, and I personally had this happen when I was house shopping, and the consultant or for the builder said that, oh, we're not accepting any more inquiries, and you know, you can't tour the home, the model home, and you know, referred me to actually someplace else. But later, I actually saw that he let another person in to tour the home, and actually gave the person more assistance. So, you know, those are some examples. Setting different standards and conditions. You might say, oh, if you have a family, you're only supposed to stay in this building. You can't stay, you know, in a building where everyone else is, where they made separate provisions for people who have families, providing different housing services, falsely denying that housing is available for inspection. That's another example when someone is interested in renting. Advertising with respect to the sale or rental, you know, that indicates preference or limitations, or, you know, seeing someone who is maybe bisexual, or based on their sexual orientation, they can only rent, they can't rent here, is an example of that. Imposing different sales prices and rental charges. I've seen that too, where someone might inquire about a renting, and they are given a different price from somebody else. So those are some examples. Some other examples, and this is a pretty long list, but particularly in retaliatory situations, and Pete mentioned this a little bit earlier, sometimes when you're making certain requests or exercising your rights to have the landlord make certain requests, including filing maybe a HUD complaint or a fair housing complaint against the landlord, and the landlord takes adverse action to evict you based on what you did, filing a housing discrimination based on your race, that might be discriminatory. Harassing a person, failing or delaying performance of making repairs, limiting privileges or services. I mentioned this earlier, assigning a person to a particular building or section of a building, refusing to provide or discriminate in terms of conditions of homeowners or renters insurance because of color, race, religion, disability, or familiar status, or national origin. So what can you do? You can call, you can report it, file a fair housing discrimination complaint online with HUD. The biggest thing to note here is that it has to be within 1 year from the discriminatory incident. But it's a very simple process online. It's not intimidating at all. It's a page and it's only about maybe 4 questions. And it's fairly simple to fill out online, or you can call or either mail your complaint to HUD, which is the Department of Housing and Urban Development. The regional office here is in Fort Worth, and obviously you can go through the regional office and make a complaint. You can also contact the Texas Workforce Commission. They have a civil rights division that enforces fair housing. And a lot of times what HUD will do is actually refer it to the local agency in your state that has a civil rights or fair housing division to handle. And most of my cases, unfortunately, I believe for me, has been where HUD is actually, I filed a complaint and HUD is transferred it to Texas Workforce Commission, which is sometimes a little bit harder to make sure that you're voicing your complaint and they are actually processing it and making clear-cut determinations of violations when it's civil rights issues that's been clearly violated. What else can you do? Well, you can call Lone Star Legal Aid and qualify for our services. Apply online, or you can give us a call. You can also seek a private attorney who can assist you if you feel like you've experienced housing discrimination. So, does anyone have questions? No, it was a lot of information. So thank you for your attention, and you're welcome to ask any questions and we will try to answer them. You can also go online. We have a lot of information online that's available to people on these same topics. We're on Instagram, Facebook, and you can also call us at the 1-800 number as well.
I had a question, but I think you've answered it. Okay, how when you have a request for something, like if they have the maintenance portal or whatever, you said like just to like screenshot, like make a copy, screenshot, or but still also send it in writing just to make sure.
Yeah, I would do that. Belt and suspenders, document, and save. So I would submit it through whatever resident portal is available, wherever it said to do so in the lease. You can email if you want. You're never going to over notice them, but you could under notice them. So it would do those things, and then I would also mail it, regular mail, and by some sort of trackable mail.
Mm-hmm.
Might seem like overkill, but you'll definitely believe this. Every landlord's first statement once they get faced with a lawsuit is, I never got notice. I didn't know this was happening. They sent it to the wrong person. So avoid that happening and make sure you send it to every possible place you can. multimedia blitz so that you can avoid that argument from the landlord that, well, we didn't get it, which can cause delay or more damages for you as a tenant.
Which is an important thing to note because as everyone knows now, everything is online. I mean, you can't even go anywhere to sit down to ask questions. They'll refer you to go online to, do everything. And so a lot of these apartment complexes have set up, what they call where you can submit work orders and you will submit your request and they will tell you, if you go into the leasing office to make a request, they'll say, no, go on the portal. But as Pete mentioned, sometimes with that, you may not get a copy of it or whatever might happen. You don't get that saved, but certainly at the very, very minimum, if you do go through the portal, you should make sure you save it. Be helpful.
Well, thank you. Connect with us on social media or check out our medical legal partnership clinics online. And if you're needing medical services, go to one of the UTP clinics we partner with. And you can also get legal services through Lone Star with our medical legal partnership with them.